everyone. Welcome back to Crime in Court. This is the Commonwealth versus Karen Reed Trial 2.0. We're heading into Trial 2.0. We're about 13 days away. If that doesn't change, I'll give you an update on that in a second. But right now, this is episode 132, No More Proctor and Another Buffer Zone. So, as you can tell by the title, Proctor has been terminated. So, that is good news. We're going to go over the trial board finding and a statement from Colonel Noble. And then we're also going to go over the defense witness list, which just came out this morning. So these are both breaking news. So Proctor's terminated and the defense witness list has just been released. We're going to go over some of the expert witnesses' bios as well. And then we're also going to go over the Commonwealth's motion for a buffer zone. Again, they want a buffer zone. Last year they had one, I believe it was about 200 feet. And now it is, I think they're asking for 500 or something. Like they're trying to extend it. So we'll read that and then what else? Oh, so this week on the 18th, so yesterday, there, yes, yesterday. I'm sorry, I didn't feel well all day yesterday, so I didn't really do anything other than watch hearings, but now it feels like that was like days ago. But anyways, so I watched the trial, the hearing with Karen Reed. She was back in court. They were going over motions in limine. First off, basically, Judge Bev decides that she's going to scold the defense, but and say that she doesn't trust them. She believes that they lied to her and they were misrepresenting things and blah 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 blah. But she's not going to do anything. There's no sanctions needed. So, like those two things don't make sense together. So she's either lying about thinking that they're lying, or she's just really like she has no backbone and just won't do anything. I don't know. I don't know. I don't know what it is, but that's what happened. The first beginning part of the motion, she basically scolded them and told the world that was watching that these people aren't trustworthy, like all of the defense team aren't trustworthy and we shouldn't trust them. And basically, I think she's done more damage to tainting the jury pool than anyone by being so snarky and rude. She was extremely snarky with the defense team, especially Alan Jackson. So, well, one of the things they had argued, I can't remember all of them, and I'm not going to go over all of the motions, but they did argue about the ARCA. And she said like right off the bat, we're going to allow ARCA. So she denied the Commonwealth's motion to exclude their testimony, so they're able to testify. So that is good news. Additionally, they're trying to, we went through all of the motions. She really didn't rule on a whole lot. She told the attorneys like go back and work it out. Like, well, why do you think it's on a motion? Because they can't work it out, so they need some kind of resolution. That's usually how you lawyer. But anyways, and then so she didn't rule on a whole lot of things from the bench, but then they went on a break, came back, and Alan Jackson, I guess we didn't see this in the docket, but Alan Jackson has filed a motion for a continuance because of the fact that the federal appeal is ongoing with the First Circuit. And in addition, the attorney that is basically representing Bev, the court, the attorney that's representing the court in this appeal, because Karen Reed's appealing her double jeopardy right. So basically, the person that's representing Bev was in court and he argued even that more time and waiting on this appeal would be better. However, I don't know if that's even going to be the case because you don't know if they're going to take it up. You don't know if they're going to rule anytime soon. You don't. It takes a long time for these proceedings to take place, and then after you have your oral arguments, then it could take months for the Supreme Court to come back with anything. So if they even do. So um basically I don't think that the continuance is going to work. That's my opinion. A lot of people are saying it's not going to happen April 1st. I don't see Bev doing this, allowing a continuance. And basically, I think she has to allow a continuance for the feds to like speed up their process or something. I have no idea what I heard that on something. But anyways, there's no incentive for Bev, of course, to delay the trial. So I think trial is going to continue April 1st. We're 13 days away. That's my take on it. If anything changes, I will post it or let you know. And at this point in time, 13 days from trial. So let me shrink myself and let's get started here. Please hit that like button and let's begin. So, up first, I wanted to read you the trial board findings. This is dated today, Wednesday, March 19th. The finding of the trial board held on January 15th, February 10th, and March 13th. So there were three different trial boards. Two of them lasted an entire day. The March one lasted, I think, into the afternoon. In pursuance of personnel order ending in 005, dated January 6, 2025, having been approved by the Colonel slash Superintendent Trooper Michael Proctor, is hereby found charge 1, specification 1, guilty, specification 2, guilty, specification 3, guilty, charge 2, specification 1, guilty. So he's guilty on 4 specific charges. We don't know what they are at this point. So Trooper Proctor, on various dates between January 29th, 2022 and August 17th, 2022, did fail to conform to the work standards established for the member's rank, title, or position, and or fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. So he effed up something regarding an investigation, it seems. Wait a minute, I'm a highlighter here. All right, so this occurred when Trooper Proctor, while assigned as the lead investigator in a homicide investigation, sent derogatory, defamatory, disparaging, and or otherwise inappropriate text messages about a subject in that investigation to other individuals. This action is in direct violation of Article 582. This is a Class A violation. Trooper Proctor, on various dates between January 29th, 2022 and June 9th, 2022, did fail to conform to the work standards established for the member's rank, title, or position, and or did fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. So basically that's the same thing, just different dates. Um, this occurred when Trooper Proctor, while assigned as the lead investigator in a homicide investigation, provided sensitive and or confidential information about a homicide victim, potential witnesses, and or potential investigative steps to the investigation to non-law enforcement personnel. So his little buddy text message chain, basically talking about, will the homeowner's a Boston cop, will he catch any heat? Nope. You know, all those conversations, that was inappropriate. This action is in direct violation of Article 5.8.2. And this is another Class A violation. Trooper Proctor, through his actions on various dates between January 29th and August 17th of 2022, did fail to conform to the work standards established for the member's rank, title, or position, and or did fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. This occurred when Trooper Proctor, while assigned as the lead investigator in a homicide investigation, through his unprofessional and inappropriate conduct, created an image that he was biased in his dealings with a homicide suspect and or brought otherwise himself and the MSP into disrepute. So he basically destroyed his reputation and the MSP's reputation. So that is in direct violation of same article. Also, Class A violation. Trooper Proctor on July 19th, 2022, did consume alcohol while on duty and not in the performance of duty, and while acting under specific orders from a supervisory member or proper authority. Who? What? He was under specific orders from a supervisory. Oh, okay, so meaning he was on duty. Sorry. So that was just a long-winded way to say he was on duty and drinking. This occurred when Trooper Proctor consumed alcoholic beverages while eating dinner on duty and then proceeded to operate his department issued cruiser. As we know, he testified to this at trial. This is what got Kevin Albert on the Canton PD suspended for several weeks with pay for driving. And he lost, Kevin Albert lost his badge and gun. And the next morning he was like, "Have you seen those?" And Trooper Proctor, I think he had both he had left both in his cruiser. So that is the story there. And that's who he was drinking with. I don't know any other details. That's basically all we know. So this action is in direct violation of Article 5.10.4. This is a Class B violation. Trooper Proctor, as a result of his actions, shall be terminated, dishonorably discharged. And that was signed by Jeffrey D. Noble. We also have a personnel order here that says, in accordance with MGL and the rules and regulations governing the Massachusetts State Police, the below named officer is hereby dishonorably discharged effective Wednesday, March 19th, 2025. So that is those are the findings. We now know Trooper Proctor terminated, dishonorably discharged for his misconduct. Those are the four things that they found. I don't know if there was more that they're not disclosing to the public, but those are the four things that we knew about that he testified to. Those are the things that have been made public at this time. I don't know if there was more investigating that might have led to some other, finding other misconduct, but this is strictly on the Karen Reed case. All right, so I'm going to pull up here the a statement. This is a statement released by the family of now fired Massachusetts trooper Michael Proctor. We are truly, and by the way, also this past week, they came out. So the family of Trooper Proctor came out and did a whole media statement thing. Conveniently, after a gag order has been placed on the attorney, so Karen Reed can't respond back. But basically, they made it seem like Karen Reed is responsible for all of the stuff that's happening to them and their family and how horrible it is, and they're just victims. So they came out with these statements, and now here's their statement after Trooper Proctor has been officially fired. We are truly disappointed with the trial board's decision as it lacks precedent and unfairly exploits and scapegoats one of their own, a trooper with a 12-year unblemished record. It's not unblemished because they found things that he did. And even if it was unblemished up until the Karen Reed trial, it's still not unblemished because he did things in this case that are unethical, considered misconduct, and it was enough to fire him. And they even fired him before the trial started, which is great for Karen because that helps her case, and Hanky Spanky's going to be a little more hesitant to put him on the stand now and to talk about him because of this whole thing. But they'll probably make they'll make Proctor out to be a victim or something, is my take. Which is probably part of this whole strategy of, getting Elizabeth and Courtney Proctor, so his wife and his sister, to come forward and speak out. I think they're indirect. I have no proof of this, but I think they're working directly with the prosecution and having some kind of media strategy so that, he puts the gag order on and then these two speak out about Proctor. But anyways, so we are disappointed. He's got an unblemished record, blah, blah, blah. Despite the despite the MSP's dubious and relentless efforts to find more inculpatory evidence against Michael Proctor on his phones, computers, and cruiser data, the messages on his personal phone referring to the person who took the life of a fellow beloved Boston police officer. It's either trying to like do the sympathy card here, like, oh, poor victim, and we're victims, and she's just the one who did it, and she's spinning it all. They are all that they found. So just the misconduct in the Karen Reed case is all that they found. That's it. So he should just keep on going being a MSP officer. No, thank you. The messages prove one thing, and that Michael is human, not corrupt, not incompetent in his role as a homicide detective, and certainly not unfit to continue to be an MSP trooper. I disagree highly. He showed his bias, and he can't follow the rules. He needs to be held to a higher standard than the rest of us if he's out there protecting us and investigating homicides. He shouldn't be biased. He shouldn't be getting so angry, according to him, that he just said horrible, vile things about somebody. That's not okay. So, no, he's not fit to be an officer. I need to make this a little bit bigger. All right, so Proctor and his detectives led a meticulous and thorough investigation of integrity, and despite today's wrongful termination and great harm and defamation this case has inflicted on him and his family, Proctor still believes justice will be served. He is grateful for the unrelenting support of the union and the men and women of the Massachusetts State Police. His heart is always with the family of Officer John O'Keefe, who continues to endure a prolonged and unimaginable nightmare. So, blah, blah, blah. We're the victims, and Karen Reed's an awful human being, and whatever. That's basically what I got from that. All right, let's move on to the defendant's prospective witness list. So now comes the defendant, Karen Reed, in the above captioned manner and provides the following list of prospective witnesses. Ms. Reed also reserves the right to call any of the witnesses included in the Commonwealth's witness list. So not just these people, but anyone in the Commonwealth's list, we want to call them. We want to be able to call them if we need to in rebuttal or for whatever reason. So yeah, so if necessary. All right, so here we go. Here is Brian Albert, Caitlin Albert, Christopher Albert, Colin Albert, as the prosecutor in Turtle Boy's case keeps pronouncing his name Colin, but it is Colin. Colin Albert, Julie Albert, Kevin Albert, Nicole Albert, Michael Wagner. No idea who some of these civilian people are. Cheryl Waugh, or Wow, I don't know how you say that. Paul Makowski, Leslie Bernstein, Rebecca Bazin. I don't know who these people are, but they're new names and it might be interesting. Maybe they have some character witness info about Karen or John, or I don't know. Maybe some of the witnesses. They might impeach some of the witnesses that the Commonwealth may call. We also have, which he was absent from the Commonwealth's witness list, but the defense is going to call Officer Nicholas Barros, who was the officer who said Karen Reed's taillight. He's the Dighton police officer who was there for the towing of Karen Reed's car from her parents' home, and he said that the taillight was cracked, not damaged. It was cracked and missing a piece, but it wasn't completely damaged, I believe were his words. So that will be interesting if they go deeper into that. The defense did not cross him in the first trial. So they will have the opportunity to bring him up on the stand. Trooper Evan Brent, don't know who that is. Sergeant Yuri Buchanan, we know that name. Lori Cahill, not sure. Trooper Zachary Clark, Christopher Curran, Carrie Curran, Nicholas Curran, Richard D'Antonio. I don't know who the Curans are, but maybe they are again impeachment character or impeachment witnesses for the Commonwealth witnesses. Officer Kelly Deaver. I believe she was the female officer who walked in while Michael Proctor was messing around. She's on the Sally Port video, and she walked in the door and saw there was some like something going on at the tail light, and she turned like she totally turned direction and left the area when she saw that. Or so that is the rumor. All right, so Stephanie Devlin, not sure who that is. Trooper David DeChico, he was one of the troopers that Trooper Proctor was talking with about getting the ME to change her determination for the cause of death. And Trooper DeChico was like basically calling Trooper Proctor weak for not being able to get her to change it. We got a Patrick Haggerty, a Maureen Hartnett. She's a lab tech, I believe, who did like the swabs, especially on John O'Keefe's clothing and arms, I believe. Or no, they never took swabs of his actual arm. They're just of the clothing of his arm. Then we have Brian Albert Jr., Brian Higgins, Louis Justress, who I believe he's with the Public Works, and he might be talking about the records for the plow drivers. We got a Trooper Connor Keefe, a Matthew Kelly. We have the Kolakithases, Karina and Nicholas Kolakithas, who both were out drinking that night, I believe at C.F. McCarthy's, with John and Karen, and they testified to them being lovey-dovey. Karina was actually like, I told my husband, why can't he be more like that? Why can't we be more, affectionate with one another and stuff? So she's the one that testified to that, and they were not on the Commonwealth's witness list, but I'm glad that they are on this witness list. Terry Kuhn, I believe she's another lab tech or something that testified for the Commonwealth last time. Sergeant Michael Lank, Brian Laughran, that's Lucky Laughran, who is the plow driver who did not see the body at 2:30 and then couldn't get past there because there was a Ford Edge. He couldn't plow the 34 Fairview Road because of the Ford Edge that was right in front of where John O'Keefe's body was found. We have Heather Maxon. So Richard D'Antonio and Heather Maxon are the individuals. Also, Ryan Nagel is the three individuals that were in the Ford F-150 that was behind Karen. It was Ricky's F-150 who was driving, and they came to pick up Julie Nagel, who all of a sudden just decided that she was going to stay longer, but then wanted Brian Nagel and them to come inside, and they declined, and then they left. So, may have been a drug drop-off. I don't know. I'm just suggesting something. But I have no clue if that's true, but it just seems a little odd that would happen. All right, that she would want to be picked up, and then she's like, "No, I'm going to stay the night." And then she doesn't stay the night. In fact, she gets a ride home later. So the whole Julie Nagel ride home, staying the night thing is all sketch. So that is the three that were behind Karen. They didn't see the tail light was cracked. They did not see John anywhere in the vehicle or outside the vehicle. Steve Nelson is the one who leaked in the very beginning, in the first few days, right after Karen was indicted, that Karen may not have anything to do with it, and it might just have been the people inside 34 Fairview Road, and they might need to investigate them. Steve Nelson then got cold feet and didn't want to be a witness for the defense. So now he's a witness on the defense list, and here we have him. All right, now up next is an Andre Porto, Holly Price, Trooper Kathleen Prince, Elizabeth Proctor. So Trooper Proctor's wife is on the list. Michael Proctor, Carrie Roberts, Wendell Robbery. I believe he's an EMT or firefighter. Can't remember. Stephen Ridge, Humberto Hernandez, Mark and Alfredo Lapalato. Those are the Lapalato brothers who had an incident with Michael Lank, who is one of the investigators, good buddies with Chris Albert, got into a fight, was very using his power to basically create an issue. They got into a fight. Basically, he was using his aggression or being aggressive, Mike Lang, and he was actually drinking. Prior to that, he decided to like initiate, or go on duty right at that moment when these two individuals were messing with Chris. It's a long story. I don't want to get into all of it, but it was years ago too, so it's probably never going to come in. Judge Bev's not going to allow it, but they would impeach or at least go to the credibility and ethics of Michael Link. So that would be interesting if we could hear from them. We have an Angela Malvone, Lieutenant Brian Tully, Courtney Proctor, who is the sister of Michael Proctor. So that's interesting that she's on there because I don't believe that Elizabeth or Courtney were ever on the list as witnesses. And now the defense is possibly going to call them. It might have stuff to do with, witness intimidation if that ever comes out. And their role in intimidating people who were saying bad things on social media about her husband. So, well, Elizabeth, but Courtney's brother. So we'll see what happens with that. If they ever get called, that would be kind of interesting. We also have Tristan, I can't tell, Time Morris, who testified for the Commonwealth last time. He couldn't remember anything when it came to time and couldn't provide any significant value. But the defense might bring him on, which is interesting. Jean Demulis, Mary Souza, Ashley Bell, Mike Rushworth. I don't know who any of these people are. Matthew Amory, Norfolk County District Attorney Michael Morrissey, who I don't know if Bev will ever allow him to be on the stand, but that would certainly be something that the world would tune in to watch. We have Thomas and Aaron Beatty. Supposedly Aaron is the one who Colin Albert decided that he was going to, or he called her at, around the time of when John's body may have been severely injured, that he called her for a ride home to get him out of there. And I don't believe that she did. I don't know, but and then if you remember, we went through the timeline of Jen McCabe like long ago in like the early episodes. We went through the timeline of Jen McCabe's phone calls, and those included several to Tom Beatty in the morning, or in the early morning when they were driving around. So I would love to hear from what those two have to say, and I really do hope that they call those witnesses. Then we have Megan Mariani, Thomas Martin, no idea who those are. Then we have John O'Keefe Sr. So John O'Keefe's father might be coming to the stand. Also Lieutenant Fanning, who, as you know, was well, maybe you don't know, he was part of that text chain too about no nudes and things like that, I believe, and didn't do anything. He was found or he was investigated, but they didn't find anything. They said it was unfounded. The allegations were unfounded or something like that, but they couldn't, like, they didn't actually rule them out. So I don't know. So they're calling John Fanning. He also is the one that was the lead investigator in the Sandra Birchmore case. Matthew Kelch, Thomas Kelleher. Oh, so the officer across the street who supposedly had a ring camera. That's not supposed. He definitely had a ring camera and it didn't catch anything, supposedly. And also, supposedly, he gave them the red Solo cups to collect John's blood in the snow. He lives right across from 34 Fairview. Annie Chung, Helena Rafferty, who is the current deputy, or I'm sorry, the current chief of Canton Police. She was the deputy chief of police, so second in command during the homicide investigation while Kenny Berkowitz was on medical leave. So that, in fact, made her number one in command, if anybody's keeping tabs. Irina Scorti-Bello, who's the ME, Trooper Jeffrey Kutzkowski, Trooper Joseph Paul. The crime scene just talks to him. Um, Paul J. D. Giampietro, he's the retired officer who supposedly had the extra Sally ports on somewhere, saved somewhere, and never disclosed it until after the first trial. Sergeant Paul Gallagher. Now we get to who I believe are all the expert witnesses. So remember, what's his face? Hank said that there were 12 witnesses in a motion. So I think these are the 12 expert witnesses. So let's talk about them. So we've talked about some of them on here. So we know of Richard Green, we know of Daniel Wolf, we know of Andrew Rentschler. These two are the ARCA experts. Andrew Wolf and Daniel Rentschler. Richard Green is the data forensics guy who found the house long to die in cold. Then we also know Dr. Marie Russell, who testified in trial one. So those are the four that have already testified in trial one. So let's go through this list one by one, excluding the ones that have already testified. So I'm going to move my list over here so I can see it. Whoops. Hold on. Okay, I got it. So up first, we've got Chris Van E. So I can't be entirely sure that these are the exact witnesses that they are calling, but after doing some research and reading a little bit about their bios, I think these are probably likely the witnesses that are going to be called based on you know, what I know about this case. So this is Chris A. Van E., who is he's a biomechanics and accident reconstructionist. So he's done research on injury with application to product safety and design, injury causation. So he does a lot of research on that. He's a biomechanical engineer. He's got a PhD, a bachelor's in mechanical engineering. Um, what else? So he also teaches. He's licensed. He's a professional engineer in the state of Michigan. Personal affiliation certification. I'm not going to read through all of this, but you can see he is he teaches this stuff, so he's pretty well versed in what he's doing. Can I make this bigger? It's not. Oh, that's much better. Okay. So what else? We've got musculoskeletal stuff, clinical neuro prosthetics, whatever that is. He knows stuff. He's in journals, he's got honors and awards. He's in several publications. This guy, tolerance of the skull to blunt ballistic parietal impact. Like this guy is good. He's going to be a good witness, I think, hopefully. Um, many publications, many presentations. I'm not going to read them all. Obviously, there are many. So that's Chris Vanny. The next one on the list is a Maggie Gaffney. Whoops. Here's Maggie Gaffney. This is a LinkedIn page of a Maggie Gaffney, who is a course developer and instructor and a mobile forensic expert out of Florida. She's a digital forensic examiner with 25 years of professional experience in law enforcement, public service, and private sector. I bet they're going to try to exclude her too, because she's a former MSP. She specializes in the collection, including advanced data extraction methods, processing, and analysis of complex digital evidence from all types of digital media. Currently working for Teal Technologies as the Director of Services, as well as a course developer and instructor. So she's been working um, as a director of services and digital forensics examiner, course developer, and look at this, 21 years and 4 months as a Massachusetts State Police trooper. What? Look at this. Look at this. This is exciting. I think she might speak to investigatory processes and things like that, and especially what you would do with a phone and whatnot. So here are her former positions. She was in Braintree, Massachusetts, Russell, Springfield. She was a trooper of computer crimes investigator and a forensic examiner for 12 years. This chick is, sorry, I don't mean to call her a chick, but if this is the Maggie Gaffney that they have on their witness list, which I assume it is because of her MSP background, this woman is going to be a solid witness for the defense. So that is exciting stuff. All right, who else do we have? This next on the list is Derek Ellington, where I found this Ellington Digital Forensics, where they do all sorts of certified forensic examinations. This is the expert's credential. So it is a company, so it's not just um, Derek Ellington, but he must be the president or someone, it's named Ellington Digital Services. He's probably the CEO. Um, so they do consultation, investigation plan, evidence handling, reporting, computer and mobile forensics, network forensics, cloud storage analysis, litigation support. So this guy's going to be good. This is going to be good for the Sally port and how, was it stored properly? The computer forensics part of it, not having the impact of not having the metadata. He might be testifying to those kinds of things. Here is his Derek Ellington's curriculum vitae that I found. If this is in fact the Ellington, which I assume it might be, but you should never assume. So this Ellington, President Ellington Digital Forensics. That's where he works presently. He's a certified forensics examiner, e-discovery consultant, IT consultant, forensic data acquisition and investigation, mobile device forensics expert witness. So he's competent in digital forensics, intrusion detection, cloud-based data, hard drive data recovery. So again, I think this really goes to the Sally port. Networking routing, SQL, operating systems, mobile device forensics. So he might talk to the House Long to Die in Cold as well, potentially. But I'm thinking this guy would be a strong witness for the Sally Port video. But he also has proficiencies, I'll say. He has proficiencies in Cellbrite technology as well, so he probably could testify to the House Long to Die in Cold search. Here are lectures and publications that he's given. There have been many. He's out of North Carolina, so most of these are there. More presentations and things given. Classes, seminars, online training that he has done. So, whole list of he keeps up to date with all these different technologies and things. So that is Derek Ellington. Up next on the list is a Michael Easter. We've heard this name because the defense has the Commonwealth has filed a motion in limine to exclude Michael Easter's testimony. Michael Easter actually is a former FBI agent, and let's see what he uh, a little bit more about his background. So, Mike Easter is a retired FBI special agent with over 20 years of investigative experience and over a decade of experience as a national asset with the Cellular Analysis Survey Team, or CAST, as it's also known. He works thousands of cases involving the analysis of mobile device location information to locate victims and subjects of kidnappings, homicides, robberies, other violent crimes, and national security matters. You think he might be talking about John's cell phone location? And how that was analyzed by Nicholas Guarino, who is not qualified because he can't even find one out of 32,000 text messages between Sandra Birchmore and Matthew Farwell. We couldn't even find one, yet we're supposed to trust him that his location data that says where John's located and where John's phone is, we're supposed to trust that that is accurate. I don't, for one, trust him. So over the course of his career, Mike Easter's career, he designed and created the curriculum that the FBI used to teach law enforcement partners the methodology for using mobile device location information. So he literally wrote the course on this to find the missing, the lost, and the hiding. So further, he has been an expert witness in over 200 criminal cases and has taught expert witness testimony for over a decade. He pioneered the FBI's critical incident response course, equipping investigators with essential skills in real time crisis management and advanced investigative techniques. As an FBI instructor, he honed his ability to deliver complex information effectively to diverse audiences, fostering strong rapport and trust even under pressure. So he's going to be relatable, I think, to the jury as well. He's going to dumb it down for us lay folks who don't understand and I'm one of those lay folks that needs it dumbed down. That we can't understand that, data technology stuff, so maybe he'll make it make sense. And so what else? His services include consulting related to call detail records with cell site location information, timing advance records, RTT records, a bunch of letters there, Google location history. So maybe that might help us learn where How's Long to Die and Cold Search came from. Tower dumps, vehicle telematics. So he's also qualified in vehicle telematics and cellular module stuff. So maybe he'll tell us Karen Reed was home at a specific time. Or maybe he'll tell us we can't determine that she was home at a specific time because the Commonwealth destroyed the evidence, which might be the more appropriate answer. He does mobile device records, discovery material, geolocation, mapping, data analysis, and reports. So, again, he could probably do geolocation of where John's phone was located. Was it inside the house? Perhaps. In addition to the services provided under case consulting, I also create an expert mapping and report from my analysis of the case matter material. Further, I will help you understand what the analysis demonstrates and how to best use this information in your case in chief. I will help you review and critique the other experts' mapping and report, then provide direct or cross examination assistance of the expert witnesses. So he can actually provide, if you're using him for consulting purposes, he can provide recommendations on what to ask other witnesses about regarding this topic or these topics that he is knowledgeable in. So that is Michael Easter. He sounds like a great witness. Again, 200 criminal cases that he's testified in. He's been with CAST. He's literally, for 20 years, he's been with the FBI, literally wrote the curriculum for the FBI to teach law enforcement about mobile device location and things like that. So, great witness. Great witness. These are all great witnesses. Up next, we have a Matthew Erickson, who we've heard from him in affidavit form. He is a computer and mobile forensic analyst at USA Forensics. And he's been with there 8.5 years. He has tons of experience in other places. He is the one that went to the Canton Police Department, tried to get all the Sally Port data, tried to get the metadata and all that, and was told it was deleted by Colleen Crawford. So that is Matthew Erickson. And we've heard from him via affidavit multiple times now. Up next is a Matthew Matthew DeSogra, who is a director of engineering at EDR Services. I think he's going to be talking to telematics. He's got a PE license, joined EDR team, mechanical engineering from UNC. Fun fact, he instructs an SAE course called Accessing and Interpreting Heavy Vehicle Event Data Recorders. So that's why I think he's going to be talking about the telematics system, I think. All right. And finally, Elizabeth how do you say that? Laposada. Elizabeth Laposada, who's an expert in anatomic. She's a forensic pathologist. She's an expert in anatomic clinical pathology. Dr. Elizabeth Ann Laposada, I'm going to get it eventually, has been retained as an expert witness in cases related to negligence, criminal law, products liability, etc. Based on our previous research and publicly available records, I don't know who these people are some of the judges who have presided over these cases that she's been involved with as an expert witness. The La Posada has the experience of working in courts like the United States District Court for the Northern District of Georgia, Atlanta Division, U.S. District Court, Southern District of West Virginia. So these are all different courts that she has um, testified as an expert. It doesn't really give us a whole lot of information about what she does. This is like some this is a website called Expert Witness Finder, and so you can find witnesses on here, but unfortunately, it doesn't give me a whole lot of information. She's like really experienced, quite well known. She teaches at Brown, I think, clinical associate professor of pathology, yeah, and laboratory medicine. She teaches at Brown University about clinical pathology, and she's an editor. She's a diplomat of the American Board of Pathology with certification in anatomic and forensic pathology. So she's probably going to talk about John's injuries if I were to take a guess. So those are some excellent witnesses on the expert witnesses on the defense team. And I think, and I did not get to Garrett Wing. I didn't pull up any information on him. We've talked about him in the past. I just talked about him in my last episode. Um, Garrett Wing was on the Melanie Little show. So attorney Melanie Little has a YouTube channel, and this was back like a year ago. He was on this gentleman, Garrett Wing, is a dog bite expert. He actually teaches police dogs and he trains these dogs how to properly bite and to lock down, whereas other dogs who aren't trained that way will bite and keep biting, whereas he goes into the whole thing. I linked it in my last video. Please go watch Melanie Little stream with Garrett Wing because it was excellent and we could all be reminded of what he said. So he has been retained as an expert for the defense also. So we got more dog bite experts. Dr. Marie Russell coming in for the dog bite and Garrett Wing coming in to talk about the dog bite. So that is going to be a very interesting defense. Once we get up there and the defense is finally on the stand, we'll see what happens. All right, now let's switch over to discuss the buffer zone. So, like I said, there was a buffer zone last time. You couldn't go anywhere near the courthouse with Karen Reed shirt or anything that said free Karen Reed or anything, basically. And I believe it was 200 feet, I believe. And they like cordoned off sections where it's like, okay, you can't be behind this line, you have to be behind this line and whatever. So, they didn't want to influence the jury. I get that. But some jurors in interviews may have said that they heard some of the chanting, but it wasn't, they couldn't really hear what it was saying, but they could hear, people. So I guess that might be an excuse as to why they want to extend the buffer zone, but I'm not really sure that it needs to be. All right, so the Commonwealth's motion for buffer zone and order prohibiting signs or clothing in favor of either party or law enforcement. So if you're a cop, you can't show up in your gear. During the defendant's first trial, the court established a buffer zone in which demonstrations were prohibited within 200 feet of the courthouse complex. The Commonwealth requests that this buffer zone be reestablished for the defendant's upcoming retrial, but with two important modifications. Of course, you can't just have it as it was, you have to change everything. So, first, on the western side of the courthouse facing Court Street, the extent of the buffer zone was inadequate to prevent such demonstrations from jeopardizing the integrity and fairness of the proceedings. The demonstrations could be heard inside the courthouse, including by the jurors during their deliberations. I think he's not exactly telling the honest to gosh truth there, though, because I don't think they could hear what was being said. To prevent this from reoccurring, the Commonwealth requests that the buffer zone be extended to include the area encompassed with Bates Court, Bullard Street, and Ames Street, and Court Street. Second, the Commonwealth requests that the court's buffer zone order expressly include a mechanism for its enforcement. Where a person is believed to have listen to this, where a person is believed to have violated the buffer zone provision and has refused requests to comply, law enforcement personnel should be authorized to use reasonable physical force to arrest that person to ensure compliance. I'm sorry, what? Where are we living here? Is this like some dystopian, futuristic, Orwellian society where we just start using force on people who are peacefully protesting? Seriously? I don't understand, but okay. Additionally, the Commonwealth requests that the court again order that individuals are not permitted to wear or exhibit any buttons, photographs, clothing, or insignia relating to the case or any trial participant in the courthouse during the retrial. So you can't wear your Gemma Cabe Googled How Long to Die in Cold shirts, even though that would be funny. All right, so background, that would be funny if everybody wore that on the Karen Reed side when Jen McCabe testified. I mean, I know it would never happen and it shouldn't be allowed, but it would be funny. All right, so the background. On March 26, 2024, the Commonwealth moved for an order barring demonstrations within a buffer zone of 500 feet around the courthouse complex and prohibiting certain items from being sworn or displayed inside the courthouse during the defendant's first trial. A group of individuals moved to intervene in the case to oppose the Commonwealth's request. The American Civil Liberties Union of Massachusetts, so the ACLU of Massachusetts, sought leave to file an amicus curiae memorandum, essentially in opposition to the request. The defendant took no position on the matter, so the ACLU was like, hey, wait a minute, this buffer zone is unconstitutional. It's, where else do you have the right to demonstrate other than, government property and on courthouses and whatnot. And they gave a whole bunch of background information. So an amicus curiae is like, I'm a third party. This doesn't affect me in any way, but here's some information because I think it would help you decide, judge, what to do in this case. And the judges all ruled that it was like too late and it wouldn't hurt. Or, they ruled after the trial and was like, well, no harm, no foul. But you get what I'm saying. So the ACLU came in and was like, this is wrong because, and the defendant took no position. Following a hearing on April 4th, 2024, the court denied the motion to intervene, granted the ACLUM's leave to submit its memorandum, which the court noted it had read, and ordered that no individual may demonstrate in any manner, including carrying signs or placards within 200 feet of the courthouse complex during trial of this court. These are Bev's words, unless otherwise ordered by this court. This complex includes the Norfolk Superior Courthouse building and the parking area behind the Norfolk County Registry of Deeds building. Individuals are also prohibited from using audio enhancing devices while protesting. So, no bullhorns or things of that nature, no like speakers to make your voice louder. Um, all right, and she also said no individuals will be permitted to wear or exhibit any buttons, photographs, clothing, or insignia relating to this case pending against the defendant or relating to any trial participant in the courthouse during the trial. Law enforcement officers who are testifying or are members of the audience are also prohibited from wearing their department issued uniforms or any police emblems in the courthouse. And that both of those came from the order from the buffer zone. All right, so that the would-be interveners filed a petition for extraordinary relief pursuant to GL 211, Section 3, in the Supreme Judicial Court for Suffolk County, challenging both the denial of intervention and the buffer zone order. Soon thereafter, a second petition was filed by an association of individuals who wished to demonstrate in the buffer zone during the trial and two members of the association. The Commonwealth opposed the petitions, and the defendant again took no position. On April 12th, 2024, a single justice of the Supreme Judicial Court denied the petitions. See Memorandum of Decision and Judgment, which is Exhibit B. The single justice held that the denial of the motion to intervene was an ordinary procedural ruling not requiring the court's extraordinary intervention and therefore denied any relief from that ruling. The single justice also determined on the merits that the buffer zone order passed constitutional muster and did not violate the petitioner's First Amendment rights. Specifically, the establishment of the buffer zone was a content neutral and reasonable time, place, manner restriction. Even though they say it was content neutral, it really wasn't because the only people that it was affecting at the time were Karen Reed supporters. So it's really not content neutral if there's no one out there supporting the Commonwealth. So yeah. Anyways. And they're saying that it was narrowly tailored to serve a significant governmental interest and that left open ample alternative channels for communication. So you were still able to protest, you just couldn't do it right on the courthouse steps, which is so dumb. The petitioners appealed the single justice's judgment to the full Supreme Judicial Court. The Commonwealth filed a response. The defendant further declined to take a position. On April 26, 2024, the full court issued an order affirming the judgment, and on May 2nd, 2024, it issued an opinion stating the reasons for the order. The court held that the single justice did not commit any error of law or abuse his discretion in determining that the denial of the motion to intervene was not a matter warranting the court's exercise of its extraordinary power of governmental superintendence. As to the petitioner's constitutional arguments, the full court similarly concluded that the restriction created by the buffer zone was content neutral and not a prior restraint on speech. It was narrowly tailored to serve a significant governmental interest, and it left open ample alternative means of communication. So basically, it didn't infringe on their speech because they were still able to speak, and it served a governmental interest by not, influencing the jury, even though the jurors come in a different location. So it's really not, it's a non issue. Discussion: the factual circumstances and concerns that necessitated the creation of the buffer zone last time are no less present or compelling today. This case continues to garner significant public interest and media attention locally and nationally, and is the subject of commentary on various social media platforms. The proceedings are still attended by groups of individuals demonstrating in front of the courthouse, displaying references to materials that may or may not be introduced in evidence at retrial, and airing their opinions as to the trial judge, prosecutors, witnesses, and the guilt or innocence of the defendant on their clothing or on signage. Perfectly good argument. Yes, this is true. This is all fact. Shown below, for example, are photographs of demonstrators who appeared despite the inclement weather. Like how they have to put despite the inclement weather. Like they'll come rain or shine. Like, yeah, no shit. They believe in this. They're passionate about it, and you guys should drop her charges, is what they're saying. So that was at a February 6th, 2025 hearing. There were still a bunch of people that came and demonstrated. This basically says, or this, all this says is honk for justice, and he's got a problem with that, but whatever. All right, so in addition, and as the court found when it issued the buffer zone order, protesters have shouted at witnesses and have confronted family members of the victims. And the victims, the witnesses, the those people have interacted, shouted back, or shouted, they've started shit. It's not like they're innocent either. Witness intimidation also remains a prevalent issue in this case, with additional criminal charges having been filed earlier this month. So they're talking about Aiden Carney's witness intimidation charge, his newest charge, from staring into a camera at D&E Pizza just so they could get him on another witness charge or witness intimidation charge. See also affidavit of Juror Doe describing efforts by individuals to intimidate, harass, and dox jurors following declaration of mistrial. Nobody did that. Nobody did that. But okay. The reestablishment of a buffer zone is therefore necessary to help ensure that both parties receive a fair retrial free from outside influences. Noting that the Commonwealth too has a right to and an interest in the defendant receiving a fair trial, and the buffer zone order also supported that right. During the first trial, the 200-foot extent of the buffer zone was adequate to prevent any demonstrations occurring on the southern, eastern, and northern sides of the courthouse complex from interfering with the proceedings inside the courthouse. On the western side of the complex, however, it proved to be inadequate. On that side, there are larger open spaces that extend beyond 200 feet from the courthouse, in particular the paved and grassy areas along High Street between Bullard Street and Ames Street and Court Streets. These areas are shown in the Google Maps screenshot below, along with a red line superimposed to indicate the extent of the 200-foot buffer zone on the side of the complex. So here's a map, which is all in black and white and blurry, so they could have picked a better image. Groups of demonstrators gathered in these areas, presumably with the property owner's permission, and engaged in coordinated shouting and chanting aimed directly at the courthouse. Really? It's aimed directly at the courthouse? Come on. How do you know where people are aiming their shouts? Even when standing just outside the buffer zone, these demonstrators could be heard inside the courthouse, including during deliberations. From the juror Doe affidavit, he says, during juror deliberations, we could hear protesters outside screaming and yelling. Again, but you couldn't hear what they were saying. You just heard noise and some other, I believe it was Ronnie, the juror Ronnie, Bowtie Ronnie, who went on Turtle Boy show and said that yeah, they heard something. They just didn't know, like they didn't know what they heard. They heard like yay and just noise. As another consequence of the 200-foot extent of the buffer zone, individuals positioned in these areas were close enough to Court and Ames streets to encourage passenger and commercial vehicles traveling on those streets to honk their horns as a form of demonstration. People have been doing this for ages. So what? He's mad that people are honking horns in support of Karen Reed during the trial, which they did rightfully so in their respective buffer zone areas, but he still doesn't like it. So this happened repeatedly, and the honking, especially from the air horns of the commercial vehicles, could easily be heard from the courthouse. That's from an affidavit? Who is that from the juror? I don't recall that ever being heard. And um, what about all the sirens? The police sirens and the emergency vehicle sirens that kept going off during trial, and we had to pause proceedings until it went away. That's okay. But anyone honking, it's just a honk. You gonna arrest them? In connection with the first trial, the Massachusetts State Police issued more than 24 citations for horn violations and other motor vehicle offenses. So, yes, they will give you a ticket if you honk your horn within the buffer zone because they're that ridiculous in how insane the rules are in Massachusetts. To maintain the integrity of the retrial proceedings and to prevent witnesses and prospective or seated jurors from being subjected to these demonstrations, the Commonwealth requests that the buffer zone on the western side of the courthouse complex be extended to include the area encompassed within Bates Court, Bullard Street, Ames Street, and Court Street. The extended buffer zone would range from approximately 300 feet to the north ends of the complex and Bullard Street to roughly 400 feet between the complex and Bullard Street along High Street. Like, okay, where are they supposed to stand? Like, why don't they just stay in their homes and protest? Is that what you're getting at? Like, seriously, you just keep pushing them further and further back. This is ridiculous, and she's probably going to allow it, but she shouldn't. She should keep it 200 feet all around. This would bring within the buffer zone those areas where demonstrations undermined the buffer zone's very purposes, while at the same time ensuring that demonstrators are not moved any farther away from the courthouse complex than is necessary to prevent those same issues from occurring. It is narrowly tailored to address the specific problems that were encountered from experience at the first trial, and it will still leave open ample alternative channels of communication and outlets of demonstrations. The problem is the demonstrators can't respond to this. They can't say, no, Hank is lying and that's not true. Or people, no one can respond to this. And Karen Reed's not going to be like, no, we don't, they're not going to have any opinion on it because it doesn't affect her trial and she doesn't want to seem like she's taking sides or encouraging it or whatever. So she's not going to take an opinion on it or a position on it. But no one gets to respond and say, Hank, you're full of crap. And no one can say they didn't hear those things or what they did hear, it was just muffled shouting or whatever. Like no one can contest what he's saying here. Oh, I missed a footnote. This continues to be a demonstration tactic as shown in the above photograph of the individual at the February 6th hearing who is holding up a sign that says honk for justice. Frequent honking has occurred at nearly every hearing in this case over the past several months and has been clearly audible in the upstairs courtrooms. Too bad. Too bad, so sad, buddy. You are in a courthouse, people are going to demonstrate and people are going to honk horns. I think he's in the wrong here for asking this, but All right, so this would bring, oh, I read that. It would narrowly tailor. Okay. The Commonwealth authors also request that the order reestablishing a buffer zone expressly state that a violation of any of the provisions of the order may constitute contempt of court and that law enforcement officers are authorized to enforce compliance. So basically, if you walk in the buffer zone with a pin, you're going to be sent to prison. That's what he wants. This is ridiculous. This is absolutely asinine. So he wants the order to state that any violation of any of the provisions of the order may constitute contempt of court and that law enforcement officers are authorized to enforce compliance with the order by using reasonable force and arresting any person who officers reasonably believe to be in violation of the order and who has refused to follow officers' prior verbal request to comply. Officers will continue to seek compliance in the first instance through verbal requests and the use of de-escalation techniques to the maximum extent possible. Do we trust law enforcement here? No, I don't trust them. I don't believe that they would do that. I think that they'll just start arresting people and saying, "Well, you violated the buffer zone." I really do believe that they could do that. And they could start getting it into their heads that, maybe we need to put these people away so that support for Karen dies down. I could see the Commonwealth doing that. And this is really dehumanizing to see this, especially if you're a protester in Massachusetts, to see that the prosecutor wants you put away in prison. But where an individual refuses to comply, officers need to be able to use reasonable force and to make an arrest to ensure compliance with the order and to avoid jeopardizing their own safety and that of the public. The order itself may provide that authorization. Courts may authorize law enforcement personnel to use reasonable force to carry out lawful orders, and courts are not constitutionally required to prescribe with exactitude the particular degree of force to be used in carrying out orders. For these reasons, the Commonwealth respectfully requests that the court allow this motion and issue an order with the following or substantially similar terms. So this is what they want. Oh, this makes me irate. The court hereby establishes a buffer zone around the courthouse complex during retrial of this case. This complex includes the Norfolk Superior Courthouse building and the parking area behind the Norfolk County Registry of Deeds building. The buffer zone extends 200 feet from the courthouse complex and further includes the area encompassed within Bates Court, Bullard Street, Ames Street, and Court Street. No individual may demonstrate in any manner, including carrying signs or placards within the buffer zone, unless otherwise ordered by this court. Individuals are also prohibited from using audio enhancing devices while demonstrating. No individual will be permitted to wear or exhibit any buttons, photographs, clothing, or insignia relating to the case pending against the defendant or relating to any trial participant in the courthouse during the retrial. Law enforcement officers who are testifying or are members of the audience are also prohibited from wearing their department issued uniforms of any police emblems in the courthouse. Why? Why would the Commonwealth not want them in their uniforms? I don't know. I think it would show bias towards Karen Reed, but like, I don't know. I think it's good that they're not show or wearing their uniforms, but I don't know why the Commonwealth is pushing for that so hard. I don't know if there's a reason that it benefits them. A violation of any provision of this order may constitute contempt of court. Court officers may eject or exclude entry to any person believed to have violated the provision against wearing or exhibiting certain clothing or items in the courthouse. Any person believed to have violated the buffer zone provision of this order and who has refused a prior verbal request by law enforcement personnel to comply with that provision may be subject to arrest. Law enforcement personnel may use reasonable physical force where necessary to compel such person's compliance with that provision. Yowzers. I really hope that this gets appealed also. But well, I don't know if she's going to approve this. I really hope that she doesn't approve that whole last paragraph. And I don't care if she extends it, maybe, and I do care if she extends it to these other streets, but I care for the people that are protesting, the people that have a right to be there. And 200 feet is already like pretty damn far. So for you to be saying that they need to extend that, I think that's ridiculous. That's where I leave you guys. So I don't know. I'm kind of fed up with Hank and his BS, and now he wants everybody arrested who violates this order. So if you walk into the courthouse accidentally with a free Karen Reed, like a mug that says free Karen Reed real small on it, and somebody sees that, you're going to jail because Hank wants you to. So don't do it. Keep all of your free Karen Reed gear at home if you're going to go into the court because they will try to arrest you and use physical force if necessary. So, what does this say about the Commonwealth? I mean, seriously, they have become so Orwellian that they want to lock up the peaceful protesters. They're not doing anything wrong. If anything, it's the blue crowd they came late in the game in the second trial who just wanted to be there to shout obscenities and try to cause chaos. Those are the people that shouldn't be there. But I mean, they have a right to it too. So whatever. I'll allow it. But I don't know. What do you guys what are your thoughts on the extension of the 200-foot buffer zone to 3 to 400 feet and then the fact that he wants to use physical force on people? Ridiculous in my opinion. Let me know what you guys think in the comments below and I will see you guys in the next one. Take care. Bye now.